Good morning.
Wow.
Good morning, Mr. Bell. Can you hear me?
Yeah, I can hear you.
Yeah, good. Okay, so I can hear you too. So I just wanted to, you can see here in the courtroom, Mr. Parker, your attorney's here. And also Ms. Malfino with the state is here. And I have already started this hearing previously in cause number 14-18993. Mr. Bell was found not guilty by reason of insanity quite some time ago for the offense of aggravated assault against a public servant. Has been in the Rusk State Hospital, and I have received request and information that a step down type facility would be in Mr. Bell's best interest at this time. And so, Mr. Bell, I just wanted to talk to you a little bit real quick. I went and looked at the house where you would potentially be going if I allow this. And I really wanted to ask you a little bit about what you have discussed with the social workers there and what your expectations are if you go. Do you know anything about the place where you're going?
Similar to a boarding home, I'm halfway house, like community care home, something like that. But it's a group home.
Right. So it's actually, yeah, and it's very, very nice home. And there would only be, I think, maximum of 2, maybe 3 of you there. So it's not a big group home. It's just a regular house in a neighborhood. And so the most important thing to me, Mr. Bell, is that you continue with your medication. Do you understand the importance of that?
Yeah, if I take my medication, I do a whole lot better than trying to go without it.
Right. So if I let you go live at this house, I want to make sure you understand that if you miss your medication, even just one time, there's going to be someone there always, and they'll make sure you take your medicine. And if you don't take your medicine, either refuse to or skip it for any reason, then they'll let me know that, and there'll be an order sent out, a warrant for you, and you'll be right back in jail and probably right back in Rusk. You understand that, how important it is?
I understand that.
Okay. Also, obviously there's rules there, just like you've been following at Rusk, and you would be required to follow those. You understand that as well?
Yeah.
And do you have family here?
Am I like in Beaumont?
Yeah, you have a sister around here?
My second to the oldest sister lives in Beaumont in a brand new house. My little brother stay in an apartment. The baby of the family, John Glenn. He lives in Beaumont.
So it would be nice, you would be able to see them, they could come see you. I do want to make sure you understand, though, that you couldn't go stay with them unless you had permission. You have to stay and live in the house, and you have curfews and things like that. You understand? You're okay with that? Okay. All right. Is there anything you want to ask Ms. Malfino or Mr. Parker?
I don't think so, Judge.
All right, so I think, Mr. Bell, what I'm going to do, I've only done this a couple of times, and you probably even know the ones that I have done this with there at Rusk and let out, and they ended up right back there a few years back. And so you probably know who I'm talking about. I don't want that to happen with you. I think it sounds like you're a great candidate for this type of home, and so I'm going to allow it. And so I just want to make sure you and I had this conversation, that you know that you have to follow every single rule exactly like they say, okay?
Okay.
And this will give you a little more freedom to be here locally where you can see family and things like that as well. All right?
All right.
So we'll get the paperwork done. I don't know exactly when all of it will take place, but it'll happen very soon. I am going to find at this time that treatment is still required, but that a lesser restrictive environment is appropriate. And I will set out an order with all of those rules with regard to medication and things like that for you to follow. And as soon as all that's done, they'll work out getting you transferred here, okay?
Yeah.
You good? Okay. All right. Sounds good. Y'all take care.
Take care too. Good.
Thank you. Mr. Stansberry, this is 26 DCCR 0174. You're charged with the first degree felony offensive murder. Mr. Burbank, what is the announcement?
Filed a rejection.
Today's charge, the offer was 40 years.
All right, let me go through that. So, Mr. Stansberry, what you're formally charged with is obviously the first-degree felony offense of murder. And that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions.
Nothing, as far as you know, not waiting on any type of discovery or
I
evidence?
think
At this time, then, I am going to find that Mr. Bonton is not competent to
Can I-
stand trial. Hang on, let me say what I need to first, and then I'll let you.
It's Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testified and take a lot of ticket tests. I'm innocent. I got the right to freedom of speech, man.
So-
I'm asking for probation, 2-year cap.
All
I
right.
can go home today because these people on the
That's not-
Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one third way.
So,
Cameron
Mr.
defended
Bonton,
himself.
you can
Jeremy
go
Dudley
back-
shot that 45.
Go
Him
back
got
with the
that clip.
bailiff. You can go with the
Yeah,
bailiff.
talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make the
Sacrifice
finding
him, man.
that inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility. Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau's charged in 2 of the cases with sexual assault of a child, and the third with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the 2 kind of most urgent matters that we've got.
Okay. I don't see that request has been made yet for the CPS records.
And not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that.
Okay.
Motion in order, Your Honor, and also, whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. And then we'll see where we are. But we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff. You are Donald Cogdill?
Yes, ma'am.
And this is 26 DCCR 0005. Mr. Cogdill was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino,
I have, Judge.
any additions or corrections?
None, Your Honor.
Judge, obviously, I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony. And the offer was made just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate, if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
Said something about parole, not parole, but like, I don't know, I don't understand what he was saying.
Okay, there's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house. And I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen. And the facts are that he was out. It started pouring down rain. He went to a house. He was on a back porch that he thought was vacant, and he was on the porch getting out of the rain. And 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up and I got scared." And I mean, and I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for a lower end.
Small Fino?
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff.
Oh,